tried to support her as much as I could, but it's gotten really, really bad lately. She's had a break. She says, I'm Nick Schneider. I've taken over Charles's body, and Charles has been killed. I'm going to kill you. You're going to be murdered today or tomorrow. I can do it. I'm out there with my priesthood, with my power. She does priesthood blessings. She does.
So who's so Nick Schneider? Okay.
That's who I'm supposed to do.
Okay. Right. Okay. So he's not at church. He's not.
She took my truck from the airport. So in fact, she took my truck from the airport last night when I flew in. She canceled my flights. I had to buy another ticket. I took him back home. I've got a 6-year-old with special needs.
Right. And he's safe at school somewhere.
Right.
Okay.
For now. If she knows I'm here, she's going to go get it.
Okay.
And that's where we begin tonight with Lori Vallow Daybell. Welcome to Law&Crime Now, everybody. I'm Jesse Weber, and thanks for joining us. It has been quite a moment here in this case because Arizona police have confirmed that they will submit their findings to the attorney's office regarding the death of Charles Vallow, Lori Vallow's former husband. And he was shot and killed by Lori's brother, Alex Cox. It has been reported that Lori will be criminally charged. In fact, a police spokesman has said that they are recommending conspiracy to commit murder. I want to bring in my Law&Crime legal analysts, Gene Rossi and Terry Austin. Great to have you both here. Terry, let me start with you. If that is the charge, what does that tell you about what happened to Charles Vallow?
Well, I hope that they ultimately do bring these charges. They're talking about bringing these charges, but, you know, I don't think that he was shot in any self-defense as Alex has been claiming. I think it was a setup. You know, Alex and Lori are claiming that there was an argument and that Alex was self-defending himself, and that's why he killed Charles. But you saw there in that clip that Charles was concerned about the well-being of Lori. He was concerned about the well-being of his adopted son, JJ, who has special needs, as he was saying. So, you know, I think it's just very, very disturbing. Actually, when we see this picture, Lori is leaning away from him, and I'd love for a psychologist to tell us, what does that mean? Even in this picture, she doesn't want to be near him. So, yes, I hope they bring charges.
Well, let me tell you, trying to get into the mind of Lori Vallow Daybell in this case might be a difficult situation. But, Gene, I want to go to you because I have a two-part question for you. This development is absolutely major. So if, in fact, she is criminally charged for the killing of Charles Vallow, A, how does that affect the case in Iowa for the charges she currently faces? And number two, how does that affect the investigation into what happened to Tammy Daybell, Chad Daybell's former wife, who died under suspicious circumstances? Her body has been exhumed and an autopsy results are still pending. But with these deaths surrounding Lori and Chad Daybell, people have questions. So again, my question to you is, A, how does this affect the current charges in Iowa? And B, how does it affect the investigation into Tammy Daybell's death?
Well, the investigation in Phoenix to the death of Charles is not going to affect the trial of both of them in Idaho. That's number one. If they do bring charges in Phoenix or in Maricopa County, they'll just have to wait until her trial's done in Idaho. Now, let's go to Tammy. What appears to have happened, just if I'm a detective, you have two people. They fell in love and they killed their own spouses so they could get married. That's probably what happened. And then they added the death of the two children as icing on the cake.
And that's a really interesting thing because it's all connected in one way or another. My apologies for saying Iowa. I have Jerry Burns on my mind, which we're going to talk about later on in the program. But so let's go back to something else that really is huge here, because we have also learned that Lori Vallow has waived her preliminary hearing. We were covering Chad Daybell's preliminary hearing where a judge ruled that there's enough probable cause for that case to proceed to trial, and he's facing conspiracy charges and also evidence destruction and alteration charges regarding the discovery of Lori's children in his backyard. But Lori, who had this upcoming hearing, she waived it. Let's take a look at that.
State of Idaho versus Lori Noreen Vallow, aka Lori Noreen Daybell. This is a remote hearing that was scheduled this morning. My name is Judge Edens here on the remote Zoom hearing. We have Mr. Wood appearing for the state. We have Mr. Means, the attorney for the defendant. I also have Miss Daybell appearing from Madison County and some IT people here to help us out. This matter is being streamed live via YouTube. This is, again, CR 2220-838. The court received information from the defense counsel that a waiver of preliminary hearing had been signed and executed, and that it was going to be filed today. The court set this hearing so that we could take up the matter and in due process vacate the preliminary hearing that's scheduled for next week. Ms. Daybell, can you hear me okay?
Again, yes.
Ms. Daybell, I have in front of me a waiver of preliminary hearing that has the title on the top, State of Idaho versus Lori Noreen Vallow, AKA Lori Noreen Daybell. Do you have that document in front of you?
I do.
Ms. Daybell, I can barely hear you. Do you mind speaking up?
I do.
Ms. Daybell, there are 2 charges on that document, count 1 and count 2, and there are 14 separate paragraphs that are listed on there. Is that the document you have in front of you?
Yes.
Ms. Daybell, did you get a chance to review this document in full with your attorney, Mr. Means?
Yes.
Do you have any questions about the document?
No.
Ms. Daybell, on page 2 of the document, under paragraph 14, it designates nothing. I just want to make sure that that handwritten thing of nothing was there at the time you signed this. Is that correct?
Yeah. It was.
Did you say it was?
Yes.
Okay, thank you. And it just below that, there is a designation that I understand these rights, and by signing below, I waive my right to a preliminary hearing. It has a printed name, and then it has a signature above that. Is that your signature?
Yes, it is.
And then you dated July 17th, 2020. Is that the date that you signed this document?
Yes.
Right below that, Mr. Means, there's a signature of an attorney. That is your signature, is that right?
It is, Your Honor.
All right, on the date there, it shows 7/17/29. I'm assuming that's a typo, is that correct?
Yes, the 29 is a typo. It should be 20. You're correct.
All right. Based upon that, via interlineation, I'm just going to cross out the 9 and put a 0 there. Mr. Wood, any objection you making that change?
I'm sorry, Judge, what's that?
I said, any objection to me interlineating that?
No objection, thank you.
July 17th, 2020. Ms. Daybell, do you have any questions about this document at all today?
No.
Do you understand what a waiver of a preliminary hearing is and what this document represents?
Yes.
And you're doing this freely and voluntarily, is that correct?
Yes.
You understand that there will be no preliminary hearing that is currently scheduled for Monday and Tuesday. That will be vacated. Do you understand that?
Correct.
You also understand that you'll be bound over to the district court where an arraignment will be scheduled in front of Judge Boyce. Do you understand that?
Yes.
All right. Mr. Means, anything else we need to take up today?
No, the only thing I'd add, Your Honor, is when the documents were signed back on the 17th of July, that was purely for logistics reasons, given the distance between the office and where Ms. Daybell is currently in detention.
That's understood. I appreciate that clarification. Mr. Wood, anything else that we need to do here on the record today?
No, not from the state.
All right, that will take care of it. We'll send notice out of the arraignment date. Mr. Means, if there's a specific date that you'd like us to consider, please let us know and we'll take that into consideration in scheduling this. Otherwise, we'll be adjourned pending that arraignment date in front of Judge Boyce. Thank you all for appearing today.
Terry, over to you. This was her opportunity to say that the state doesn't have enough probable cause to go forward. She waived it. That means going straight to trial. What's the strategy here? Why did she do this?
Well, you know, it's fairly common to waive this preliminary hearing. The only purpose of the hearing is to determine whether or not there's enough evidence to move forward to the arraignment and then further to trial. And I think that she probably had a conversation with her attorney and they came to the conclusion there's plenty of evidence to show that there was probable cause. So they waived it. It saves some money for the state. It saves some money for everyone in time. But one thing I will say, Jesse, the judge still continues, and I think this is very interesting, and I'm not sure why he's doing it, calling her Miss Daybell. She clearly is married to Chad Daybell, but I think he's just digging that in every time he gets an opportunity.
And then she requested to be called Miss Daybell. Look, Gene, I want to actually go back. We talk about evidence. I want to go back to the Charles Vallow update there. So although we, as police spokesman, said that they're going to recommend a conspiracy to commit murder charge in that case against Lori Vallow, and we're talking about Lori being charged in connection with the kids, they said they expect this within 4 to 6 months, that there's still an investigation underway. They're going through all the digital data from Lori, their subpoenas, their warrants. What are they looking for? What do you think they found that told them she's more connected to the death of Charles Vallow here?
Well, I can tell you this. If I were the lead detective in that case, I would look for communications between Lori Daybell, and her brother, Alex Cox. And I'd also look for communications between Charles, who got killed, allegedly, and Lori regarding the divorce proceedings, because I think in February of that year, he had filed a petition for divorce and he wanted custody of JJ, who was adopted. And motive is always relevant. What were they discussing, Charles and Lori, about her custody of JJ and the kids? And that could be a key. So they're looking for text messages, emails, letters, anything among that triangle to show that when Alex Cox showed up and Terry hit the nail on the head, they said it was self-defense or he was trying to protect his sister. I don't think that happened.
Well, let's talk about this. So, Terry, you listen to this and you're thinking about it. The question is, of course, why is Lori and why are Chad not charged with the murder of the kids? I ask you this question all the time. We saw a preliminary hearing, a waiver of another preliminary hearing. She might be hit with a conspiracy to commit murder charge for Charles Vallow. And yet, is it because what we're seeing that Alex Cox might have been the one who actually committed the acts?
Yeah, and I think, Jesse, that the authorities want to make sure they have all of their ducks in a row. They don't want to make a mistake here. They know that Lori was behind the whole conspiracy. They know that Alex was the one who actually committed the murder. And they know that Chad was involved because, in fact, JJ and Tylee's remains were found in the backyard. So what the authorities want to do is make sure when they actually bring these charges that no one can question the evidence they have. So I'm faithful that the charges will be brought and that they will be able to prove it through this digital evidence, through the telephone, through all of the text messages. And ultimately, the jury will have to say, yes, in fact, there was a conspiracy here to kill these innocent children.
And let's not forget, Alex Cox is dead. And that's another wrinkle in this story, trying to understand that you can't go after him now. So where does that leave Chad and Lori in this whole mess? But it should be noted that there are multiple characters in this case that we need to talk about. And when we come back, we're going to focus on Melanie Gibb, the former, I would say, best friend of Lori Vallow, who became a central figure in this case, central figure at Chad's preliminary hearing. Well, she actually sat down with an interview in East Idaho News and spoke about what it was like to testify at the preliminary hearing. We'll get into that right after this. Stay tuned.
Quite the experience, as you can imagine. A lot of mixed emotions, but overall I'm grateful to be able to share the information and knowledge that I have. There was some moments that were it's hard to talk about those things and knowing the whole world's watching you. But I was grateful to be able to share it. I had been wondering for a long time, since I knew I was going to take the stand someday, what it was going to be like. And so it was hard, but there were things that I liked about it, and stronger than I think I am. And I guess if I want to say my favorite part, I share with Nate, is I really got a chance to meet Kay and Larry. That was the highlight. Wonderful people, very grateful to know them.
And that's Melanie Gibb talking with Nat Eaton from East Idaho News about her experience to testify in the preliminary hearing for Chad Daybell, talking about the good things, the bad things. And as she said, one of the best things for her was to have a chance to speak to JJ's grandparents. Now, Gene, I want to turn to you. This is a woman who has been heavily criticized in this case. One, for the fact that she's sitting down with media constantly, including, as you just saw, Nat Eaton right after this preliminary hearing. But number two, that she didn't do more. Remember, it is alleged that Lori and Chad asked her to lie to police about the whereabouts of JJ, and she first misled police and then came forward and cooperated with them. So this whole idea that she was trying to protect herself and all this, your thoughts on her role in this case and how she testified and what she's saying now?
Well, we got three people on the screen here, and I got to say this. We like the camera. She loves the camera. The problem with her is she's a potential witness in a trial, and she should not be talking to the media, whether she's a witness for the Daybells or she's a witness for the prosecution. But the thing that just strikes me about her is, if I'm a prosecutor, she has invaluable evidence, because a lot of the things, conversations she had with Lori, supports the motive as to why she got rid of JJ and Tylee and her husband, Charles. She was preparing for the second coming. She was part of this 100,000 club, or whatever it was. This is crazy talk. And she has invaluable evidence about that. Now, whether she could have done more, she was trying to conceal a potential crime by Lori Daybell or Vallow, and that is a crime in itself. So she got a pass. I don't have much sympathy for her, actually.
Not a lot of people do, and we're going to get to that recording between her and the Daybells in a minute. But before we do that, let's just go back to that interview with East Idaho News, because Nat Eaton said, do you have a message for Chad and Lori if any way they see this? Here's her message to the Daybells.
I hope that they can realize this is pure evil. There's nothing good. The whole goal for them was to be together, and they're not. All the things that they thought were going to happen, their predicted revelations, can you not see that nothing happened the way you thought they would happen? At some point, you have to say to yourself, nothing happened. We're not together. We're both in jail. And now 4 people that were in our family are dead. There comes a point where you got to wake up and realize there's some either mental illness there, some evil influences there. At some point, you're going to have to come to that realization that you can't live in this pretended bubble that you believe in anymore. It's got to pop eventually, because you're not going to come out of jail. You're going to be there for the rest of your life.
Terry, those are some strong words from Melanie Gibb to her former friends. Your reaction?
This is what I think about Melanie Gibb. Yes, she could have done more, but thank God we have her as a witness in this case. You know, in fact, on November 26th, she did lie to the police after Chad and Lori called her. But on December 8th, maybe it took too long, but ultimately she taped the conversation that she had, and she did that for a reason. She wanted to protect herself. And I think ultimately she knew that this was going to be presented in court at some point to show what Chad and Lori did and to protect herself. So I think the rationale that she had, whether you want to accept it or not, is I need to find out what's going on here. I'm a little confused myself. Listen, maybe these two are going to come after me. So I think she proceeded carefully and cautiously until she knew exactly what she wanted to do. And then she came out. Could she have done more? Yes. Are we glad we have her? Absolutely.
You speak about the recording. Apparently, she didn't want to reveal this recording until after the preliminary hearing. That's what she told Nat Eaton. She had hinted to it. He knew about it, but couldn't report on it until after the preliminary hearing. So let's actually turn back to that recording. This again, Lori and Chad sort of suspected something was going on here with Melanie, that she might be cooperating with police, but just listen to what was this exchange between the Daybells and Melanie.
I did have a question that I asked Al at one point, your brother, if I wanted to know, like where he was, and he said I did not want to know, and that he could not be found. So what does that mean?
I don't know why he would say that, but it's the same story. Like
Yeah. I don't even want Al to know. I don't want anybody to know so that nobody has to be worried about it. I mean, nobody has to be questioned about it, so he can be safe. Yeah, so how long are you going to be away for? Like, are you ever going to be able to come out and come back to society again? Or are you going to keep, come back? I mean, what does that look like? I will do whatever the Lord needs me to do every day, so we'll see. I just wondered if I was ever going to see you again. Absolutely, you will. Okay, so maybe when they're done chasing you, you'll be able to come out of, JJ will come out again, or? Yeah, I mean, it's a ridiculous thing for them to be working with Kay to find me. There's nothing that's gone on that's, you know what I'm saying? Like, they're working with her in some dark capacity. The police are working with her in some dark capacity. There's no reason for them to be after me in the first place. Yeah, has she threatened you at all? Yes, lots of times.
Jean, let me turn to you. Your reaction to that recording and how you think it might ultimately play out at a trial for Lori or Chad, because I keep always wondering the issue of mental illness, mental health, the insanity defense, yet I'm struck by how there's such a strong level of deception here.
Well, that tape cuts both ways. If you listen to her intonation and how she's not answering the question, if I'm a prosecutor, which I was, that helps my case because it shows manipulation. It possibly helps you prove premeditation or, first degree. But if I'm a defense attorney, which I am now, she has some extremely delusional thoughts that point towards somebody who arguably was insane or suffered from a mental defect when she allegedly committed the crime. So that tape cuts both ways. It's one of those pieces of evidence you could argue one side or the other.
And Terry, people look at this case and say, well, is there a situation you have both these people coming out together, or is it a possibility one would turn on the other, or one is more responsible than the other? Again, aside from the fact that Alex Cox possibly is the one who actually killed these kids, they seem to be a united front even before we heard this tape, but they appear to be even in a more united front after this tape. What do you think, Terry?
I think the most logical conclusion is that both Chad and Lori are going to point to Alex because why? He cannot defend himself. And the argument is going to be that for whatever reason, and I think that they'll each make up their own rationale, Alex wanted to take these children out. I don't think that's going to prevail. At the end of the day, there was no independent reason for Alex to want to kill JJ and Tylee. And the explanation really is that Lori and Chad wanted to be married to each other. They wanted to be free of their ex-spouses, and they wanted to not have children tie them down. So I do think that they're going to point to Alex. I don't think they're going to point to each other. At least we haven't seen evidence of that just yet.
Jean, we have about 30 seconds. What are you looking out for next in this really complicated and sordid case?
Maricopa County. I would be following what the detectives and law enforcement are doing there because they could discover evidence that helps in the Idaho trials. So I would be watching that like a hawk.
Yeah, and we are seeing updates constantly in this case. We're all going to be waiting next 4 to 6 months. What happens with the Charles Vallow investigation? Maybe sooner. Who knows? But yeah, by all accounts, both cases against Chad and Lori are proceeding forward to trial. When we come back, we're going to go to Iowa. Jerry Burns. Stay tuned.
First of all, I'd like to say that somebody else stabbed Michelle to death in that car that night. I don't know who, I don't know why, And I would like to thank my family and friends for their support.
And yet, despite that statement to the judge, Jerry Lynn Burns was convicted and ultimately sentenced to life in prison for the murder of Michelle Martinko back in 1979. A fascinating case, a cold case that suddenly heated up when authorities used genetic genealogy to ultimately track down Michelle Martinko's killer. So, Gene, let me turn to you. What a statement from Jerry Lynn Burns right there, still maintaining his innocence. And you got to tell me, is there a strategy there? Is there a legal strategy there to make that statement during a sentencing hearing?
Yeah, it's called appeal. If he confesses to the murder, he ain't going to have an appeal. So he's trying to preserve his appeal because he's age 66. And when you're pushing 70, that you don't want to be in prison. That's the last place you want to be. So he's just laying a framework to preserve his options, because you got to understand, the DNA is bad evidence that was found in the car. It was his DNA. But other than the DNA, I don't think they had a ton of corroboration besides the DNA in the car, which is bad. And when you have a murder trial and it's a vulnerable victim like Michelle was, the jury wants to find somebody guilty. So that was his strategy, preserve his options.
Now, I'll get into the other piece of evidence that were elicited during the trial. But before we get there, if we stick with the DNA, Terry, this is an interesting case. It's a groundbreaking case in the fact that it marks one of the first convictions that genetic genealogy was used. And this idea here, because you're going to hear his attorneys and you're going to hear countless defense attorneys moving forward trying to strike at the reliability of this evidence. Because let's not forget, Jerry Burns didn't put his genetic material into GEDmatch or Ancestry.com. But what is happening, and I'm saying that in regards to, you look, the Golden State Killer or other people as well. What's happening is distant relatives are putting their genetic information in. That is matching up to the DNA found at a crime scene. And then through investigative techniques, the authorities ultimately narrowed down the suspects. Here, they went from a distant cousin to the three Burns brothers, took two out, and they narrowed it down to Burns. Do you suspect that there are going to be strong challenges against this use of this DNA evidence in the future? Or is this really strong and this is just the tip of the iceberg?
Well, I think people are going to be fighting both ways on that issue. I think you're going to have defense attorneys who are saying that's not enough, that it's just probability, and that, you know, you're looking at distant relatives. You can't necessarily narrow it down to my client. And I think you're going to see the prosecution in many states, not just out here in Iowa, but I think we're going to see prosecution say, no, this is reliable. There's 1 in a billion chance that it could have been someone else. And as time progresses, we are going to see this evidence and this genealogy improve even more. So I absolutely think it's something that we're going to see in the future. And just like the Golden State Killer, just like in this case, and there have been other cases in other states, we're going to see DNA matched in this way in the future for these cases.
And we do expect that we'll hear more of the arguments from defense attorneys saying that this is a violation of their client's constitutional right to privacy, in the sense that, how is this right? You know, they didn't submit their material, and that's going to be a fight. Now, talking about fights, before there was even sentencing, the defense, Jerry Burns' defense attorneys, moved for a new trial, and they listed a number of grounds. I want to get into that. Now, one of the things they said was that one of the state's key witnesses, who was a former cellmate or jailmate of Burns, testified against him, said Burns said some really bad things, but they're saying this guy can't be believed. He's a liar. Take a listen.
The credibility of any witness, and more importantly, what the state knew about the credibility of that witness, is of constitutional significance. It is plain that the prosecution in Mr. Burns' case, in any case, has an obligation of providing Mr. Burns with exculpatory evidence, including evidence would tend to impeach or challenge the credibility of a state's witness. We believe that experienced lawyers in this case would have been informed by the Assistant United States Attorney, by Mr. Allison's attorney, about the true texture of the legal position he was in federal court, and that failing to correct the falsehoods that I've just enumerated represented a denial of Mr. Burns' right to a fair trial.
Gene, let me turn to you. The defense brought up numerous arguments here. Judge ultimately rejected it, said no new trial. But the arguments here were everything from what you just heard, that this jailhouse informant is a liar, he's not credible, and clearly the jury might have come to a different result. B, there's new evidence that's been uncovered that would suggest that Michelle Martinko was not in fact killed in the car, so that defeats the state's narrative of what happened. B, perhaps it conflicts with other people's accounts of what Michelle Martinko was doing before she was killed. And they brought up these other areas, like we talked about, the constitutional concerns with the DNA, and yet the judge said no. The judge said no new trial. What do you think about that?
Well, I got to tell you, they have two great issues for appeal. Whether they prevail is a different matter. But for the audience, for the listeners, there are two famous Supreme Court cases on the government's duty to disclose certain information. One is Brady versus Maryland, and that is the duty to provide timely exculpatory information. And you just touched on that. If there's evidence that Michelle was somewhere else on the night of this murder, that's exculpatory information, period. And it should have been provided at trial or timely before. The other one is called Giglio, United States versus Giglio, Giglio. The government has a duty to timely provide information about a witness for the government that goes to their credibility. And it sounds like the government and the U.S. Attorney's Office did not provide to the state information about this cooperator that could have been used during cross-examination to attack his credibility. That was the Giglio case. The government had a cooperator testify. Yep.
And just to respond to that, Terry, just to respond to that, what we heard in court was the judge saying, first, with respect to this new evidence, that, you know, this could have been reasonably discovered during the course of trial. And really, the only thing that would change the flavor of this, the only thing that would really grant a new trial is if something came out after the trial, after the conviction, and yet this could have been discovered. What's your reaction to that? And let's just bring up one other defense argument here where they said that it was prejudicial and grounds for a mistrial for the prosecutors to keep referring to the DNA specimen on Michelle Martinko's dress as blood when in fact it could have been sweat, saliva, or blood. Those two arguments. Terry, your thoughts?
Well, let's talk first about the fact that this evidence, this new evidence, could have been brought up before. I think the judge was absolutely right on that. Listen, if the prosecution had information and didn't disclose it, Gina's right. There's a problem there on appeal. But there's no information that we have so far that we didn't get the evidence from the prosecution. Thus far, it just seems like to me that the defense was saying this evidence existed and the defense should have been able to get that evidence beforehand. So I think that the judge absolutely made the right decision as far as that's concerned. Now, listen, as far as the blood, I think it was a good argument. Listen, the defense attorney is excellent. And I think the fact that during the trial and motion, he's trying to say that it's not clear whether or not this DNA was blood or spittle or something else. So when the jury is thinking that it's blood, they are thinking that Jerry Burns was involved in stabbing Michelle Martinko. But listen, the judge said that cross-examination was well done and the jury could determine for themselves whether or not this DNA was blood or spittle or anything else. So I think the judge made an excellent decision.
You got to give it to the defense to try to do something here, but I think we all knew where this was headed, and that was headed for Jerry Burns to spend the rest of his life in prison. When we come back, we're going to hear from the judge, and we're also going to hear from one of the powerful victim impact statements that was played in court. Stay tuned.
At this time, a judgment will now enter upon the jury's February 24, 2020 verdict, finding Jerry Lynn Burns guilty of murder in the first degree, a Class A felony in violation of Iowa Code Sections 707.1, and 707.2 Code of Iowa. Pursuant to Iowa Code Section 902.1, Jerry Lynn Burns, you are now remanded to the Director of the Iowa Department of Corrections for the rest of your life. The Lynn County Sheriff shall transport Mr. Burns to IMCC Oakdale when there is bed space available. Mr. Burns will receive credit for each day that he spent in the Lynn County Sheriff's custody.
And that's that Iowa judge ultimately sentencing Jerry Lynn Burns to life in prison without the possibility of parole for the brutal slaying of Michelle Martinko back in 1979. Now, before the judge laid down that sentence, usually you hear victim impact statements, and the court heard a very powerful one from John Stonebreaker, one of the last remaining family members of Michelle Martinko. He's her brother-in-law. Here is what he had to say.
Judge Hoover, Janelle and I are thankful in another way. We are thankful that she fought so hard. Michelle played a critical role in identifying her own killer. The defensive wounds on her hand show it. She fought so hard that she was able to deflect the killer's knife so that he stabbed himself, leaving the blood that caught him. In a very real way. Still, Mr. Jerry Burns was clever enough to steal 39 years of freedom he didn't deserve. And he knows it. And without a hint of shame, he said as much. And in another sense, in the most selfish act a human being is capable of, he stole those 39 years and many more from a sweet, smart, talented girl who never got her chance at college, a career, marriage, children, and by now even grandchildren. While Mr. Burns has been living free without the conscience of a real man, what remains of Michelle rests with Janet now Martinko in Cedar Memorial.
Gene, it's really clear what the emotional impact is for the family and friends of Martinko, what this is like for them. But if you, as a former prosecutor, what is it like to successfully win this case? When you're talking about something from 39, 40 years ago, difficulties, challenges, and ultimately prosecuting a case like that, to win, to get that closure, what's that like?
Well, I don't know how many prosecutors were involved, but I would be incredibly proud because a cold case like this, where you really don't have a ton of evidence, you had the DNA, but 39, 40 years after the murder and you convict Mr. Burns, it's probably the highlight of that prosecutor or prosecutors' careers. That's all you can say.
Yeah, and you have to say it wasn't a slam dunk. It wasn't so easy relying on this kind of new technology, and yet they secured a conviction. And by all accounts, Jerry Burns is going to spend the rest of his life in prison. I want to turn now to our final story of the show, George Floyd, the man who died after a controversial arrest in Minneapolis, Minnesota. There has been, and you might have seen it yourself, leaked body cam footage from that arrest. A lot to break down here. We're going to show you a short portion of it. I warn you, quite disturbing what you're going to hear, but the question is, how does this affect the cases against the 4 officers who have been charged? Take a look.
You got him? Man, dang, man. Put your hands on top of your head. Hands on top of your head. Hands on top of your head. Step out of the vehicle and step away from me, all right? Step out and face away. Step out and face away.
Please don't shoot me. Please, man.
I'm not going to shoot you. Step out and face away.
I'm going to get out of here, man. Please don't shoot me, man.
Not shooting you, man.
Please, man. I just lost my mom, man.
Step out and face away. Step out and face away.
Please don't shoot me, Mr. Officer. Please. Don't shoot me, man.
Step out and face away.
Can you not shoot me, man?
I'm not shooting you. Step out and face away.
Okay. Please, man. Please. I didn't know, man.
Get out of the car.
I didn't know, Mr. Officer. I didn't know.
Okay, now it should be noted that this footage was leaked. It was obtained by the Daily Mail, and there's currently an investigation into that leak. I'll get to that in a second, but Terry, let me turn to you. Now that we've seen this, you can't unring the bell. How does this affect the prosecution of the 4 officers? How does it change, or maybe doesn't change, the narrative? I should say former officers, by the way.
Right, exactly. They're former officers. I think it's going to shed more light on what exactly happened. We know that Lang and King, they had their knee on the legs and on the back of, you know, our victim here, George Floyd. And I think showing the video from their perspective is really going to ultimately give us all an understanding of what they were doing. And it wasn't good. The fact that we heard him saying, man, please don't kill me. Please don't kill me. He was begging for his life. And we saw the perspective from the witnesses and using their phones. But now we know for a fact that these other officers, they knew what was going on. There was no confusion about it. He said he was claustrophobic. So I think it's going to be good for the prosecution. I think we're going to be able to understand from the perspective of the police officers themselves what was going through their mind and what they knew they were doing to George Floyd.
Gene, can this be utilized by the defense? Because it's my understanding, at least one of the attorneys was pressuring the court to ultimately release this footage, which was only previously available by appointment for private viewing. So my question is, does it help them? Because Tu Tao, who is the officer, never actually touched Floyd or didn't appear to be touching him, but he's the one who now is saying that his charges should be dismissed, that he was simply doing crowd control. So looking at the video, I mean, when you think about that, how does this help these officers in any way?
Well, I go back to the Rodney King case where they had videos that you would think would help the prosecution, but the four police officers in that infamous case, they used that video of them beating Rodney King to great effect. Obviously, this case is different. Rodney King lived, but George Floyd died. But this video cuts both ways. It really does. In the prosecution sense, it shows that they're not being empathetic to this man who has a lot of emotion and is not threatening in any way. But also, the police could argue we were just trying to get him out of the car. He wasn't complying with our orders. We had no malintent. And it could help the officers, at least one of them, maybe two, explain their motives for putting him on the ground. That could help the defense, could.
And maybe perhaps Thomas Lane, who is heard trying to say to former officer Derek Chauvin to turn Floyd around, that he is worried about that situation. And Chauvin said, no, we're just going to keep him in the same position. Now, I do want to ask you this, Terry, because this footage wasn't released publicly. It was leaked. As I said, there's an investigation into this leak. Why do you think the court was so keen on only allowing private viewing of this?
You know, that's a question that I had for myself. I mean, I think ultimately we know all of this footage is going to come out in court. So why the judge only allowed the, press or whomever to view it and then do transcripts and talk about it? What's the difference between actually reading the transcript and viewing the actual footage? And also, when we know for a fact that we have the footage from the witnesses who saw it, I really was a little, concerned and confused about why the judge said you can only view it and then talk about it, because what's the point? You might as well view it as well. So it was leaked, and actually I think it's good for the public to see exactly what was going on.
Yeah, and especially in a case that, inflames so many different emotions, the idea of not allowing it out, it almost appears as if you're hiding something. Then again, this is sensitive material. The transcripts were released. We knew what was happening. It's a difficult decision, but like I said, can't unring the bell. This has been obtained by the Daily Mail. It's been circulated. People are watching it. But the most important thing for prosecutors is to try to get a jury that perhaps hasn't seen this or perhaps wouldn't be affected by this. Tough job in such a case that really has captured international attention. Gene Rossi, Terry Austin, really appreciate you both coming on. Everybody out there, thank you for joining us. And until next time, be safe, and we'll catch you up on the biggest stories. Till then.